This is Boomer Time, a proactive podcast for baby boomers, about baby boomers, and for people taking care of baby boomers. If that sounds like you, then you're in the right place. I'm Nancy Kogar, an elder law attorney and aging advocate, and this podcast was made just for you. Remember, though, the things we discuss here are not intended to be legal advice, and no attorney-client relationship is established by this podcast. Hello, my friends. This is your host, Nancy Kogar, and this is Boomer Time. I hope you're doing well, and I'm happy to have you here. If you're a first-timer, I hope you'll stay. And if you're a regular listener, then welcome back. This podcast is all about creating community for us, and it is meant to be a safe place where we can learn more about all these complex issues that impact us and our loved ones as we age. On this episode of Boomer Time, I am going to tackle some simple shortcuts that folks often take thinking that they're doing just what I talked about, planning for their aging years. But in doing it, by taking these shortcuts, I am here to tell you that those can often lead to major boo-boos or painful consequences. Oftentimes, the ones involved, unfortunately, don't even realize it until it's too late. That's why I think this is worth sharing with you. There should be some very important takeaways for you today. And I bet some of you will find these things that sound very familiar. You may have even done some of them, but that's okay. In this episode, we are talking about big estate planning boo-boos that will lead to major ouchies. So make sure to stick with me too, because at the end, I am going to offer you some important and free resources that can help you with your long-term care planning. So spend the next 30 minutes with me. These are issues I want to tackle together. I've already heard from some of you, and I am so glad to know that the podcast is helping you in your circumstances. In fact, I want to say hello to Stephanie in Utah. I hope you're doing well and that transition is going well that we talked about. And a big hello to one of my favorite people in the world, Josh Robbins in Murfreesboro. Thanks for tuning in, counselor, and I would love to have you on the show. He is just great. And if you are in Rutherford County or Murfreesboro and you're looking for legal help, look up Josh. Maybe Josh will come on the show and share some of his expertise. I'm still hoping, Josh. So if you're new to the show, reach out to me and tell me what you think. Ask me a question. Maybe it'll make a great next episode. You can do all that at nancykogar.com. Okay, now our focus today is big estate planning boo-boos, as I said. And I'm going to tackle these one at a time. You probably won't see the problem with these when I mention them, but I am going to explain why these can lead to painful circumstances. So, the first one of these is quitclaim deeds. This is a big one, and I see it all the time. Quitclaiming your house to your child or children. You probably think this will get it out of your hands and takes care of the inheritance that you plan to make to your children after your death. All the while, you're also avoiding any of the other pesky details of probate, right? Well, this is a big boo-boo, and I see it all the time. And you probably will want to think twice about this one, because most of the time, people will quitclaim their house thinking it gets the house out of their hands, and as a result would avoid Medicaid or TennCare from swooping in and getting their house if the medical debts are owed following any kind of nursing home care in the future. The other big reason why people quitclaim their house is to avoid probate altogether. I'm here to tell you, neither of those are worth quitclaiming your house to your kids. And here's why. Here's just a few pitfalls, okay? 1, if you quitclaim your house, you will lose your step-up in basis. What does that mean? It means the equity that you've earned in the house over the years since you first purchased it. You will lose this right by conveying your house by quitclaim. So if you paid $50,000 for your house in 1950 and today it's worth $500,000, that equals a $450,000 gain. A step-up in basis would allow you to take the house at its present value, $500,000. But quit claiming it, you are essentially giving that all away. That could be one big, painful, and costly mistake. That's not all. 2, quit claiming your house is treated as if you're giving it away for nothing, because essentially that's what you're doing. In other words, no price paid, no consideration. In fact, the deed will state just that. Maybe you don't want your children to pay anything. That doesn't help in this circumstance. And here's 2 reasons why. First off, TennCare or Medicaid is going to treat that transfer as you giving away what may be your biggest asset. Then that may have otherwise been available to help fund your end-of-life care, but you gave it away. So that will likely get in the way of any kind of eligibility for assistance, especially if you find yourself needing nursing home care, and probably foul up the reason you did it in the first place. Secondly, if your children file bankruptcy or get into a car accident or have a divorce or other lawsuit where there's a judgment issued against them, the house is going to be the most likely target for collection. And a bankruptcy trustee is going to look to liquidate that house or set aside the conveyance you made. Even this, an IRS could levy against your house. So here's some of the pitfalls. Who says you're going to live in your house after you quit claim it? That's up to your kids too, because you will no longer own it. What if your child files bankruptcy? Did you know that your house may become part of their bankruptcy estate? And like I said, if they're sued, their creditor could put a lien on your house. What if you need money in the future? Guess what? It's not your house anymore, so you can't borrow against it. That's not an option. So that's why I say quitclaim deeds are a major boo-boo. Don't do it. Chances are you will regret it. So you can see why I want to tell you about these things. Unintended consequences. And I've got more for you. Let's just take a break first and I'll be right back. Welcome back to Boomer Time, and today we're talking about boo-boos. Here's another boo-boo that seems like a good shortcut, but can create big problems. Joint accounts. I am here to tell you, do not put one child on your checking or savings account or any other bank account if you can help it. Here's another bad idea that's disguised as a shortcut, and here's why. You are once again giving away your absolute interest in your bank account when you put a child or children on the account. Did you know that? I see lots of people doing this for convenience sake, i.e., they want the child to be able to pay bills and withdraw money from the account without any hassle from the bank. I get it, but you'd much better off using a power of attorney for that. Some of these same issues that I talked about with a quitclaim will come up. Did you know that under Tennessee law, jointly held assets vest automatically in the survivor upon the death of the other owner? So that means the bank account becomes the property of one child on the account when you die. That's to the detriment of the others. Talk about an ingredient for a family feud. I've seen it. Not only that, you've now placed that child in a position where they need to figure out how to come up with a gifting strategy over time to distribute those monies to the rest of the family as you intended. This can lead to creditor issues involving that child transferring away what is now their property, right? Jointly held assets won't be subject to probate, so your will won't control what happens to those, even if you intend for that to happen. This happens all the time and leads to big boo-boos and can also lead to expensive tax consequences and legal bills. I cannot overemphasize the problem with this, and I see it all the time. I've got a case right now where a gentleman that I instructed very specifically not to do this put his caregiver on all his accounts as a joint owner so she could pay bills for him. He died. Guess what? She is now the legal owner of almost $500,000 in liquid assets. You think that got the family's attention? I'm trying to sort that out now. Be careful when considering joint accounts. Number 3, forgetting contingent beneficiaries on POD or payable on death accounts. So there's no real requirement to designate secondary or contingent beneficiaries on your accounts. Picking at least one, of course, is always a good idea because it helps to ensure that your assets will go where you want, be payable on death. I see this all the time too. Here's the problem. If a named beneficiary is dead before you, make sure to update your beneficiary or list another second contingent beneficiary. Here's why. If you don't do that and your primary beneficiary passes away before you do, then all those assets, including any retirement accounts, life insurance policies, could all go to your estate. In that case, Tennessee's laws of intestacy could be responsible for divvying up your assets unless you have a will, in which that case the court will divide up your assets according to your wishes. All of it could just lead to a big bite taken out by the IRS, as the estate could absorb all that gain and tax liability from those assets. Not a good idea. And this relates to IRAs, 401ks. Put beneficiaries on those accounts and then put secondary beneficiaries. We don't know what the future holds. Please also know I'm not lessening the importance of some of these by calling them boo-boos. They're often difficult to understand legal concepts, so I'm using those more familiar terms here so that it helps with the understanding and retaining some of this stuff. I just want to make that clear, okay? They are boo-boos, and I just think that makes it easier to digest. Here's another one, okay? This is a big one too. Blended families. Today, the nuclear family, George Bush would say nuclear, right? The nuclear family is almost non-existent. Most of our families are very complex. They are blended in some way. Perhaps we have a second marriage and there are stepchildren, step-grandchildren that you consider your own. I've got that issue. And maybe there are people that have come into your life that you consider family, but they aren't really officially your descendants. I've got that problem too. You probably do as well. This is critical to spend some time looking at these issues. So if you have a second spouse, perhaps your first spouse passed. And I think it's great that you're blessed to have someone new in your family that you want to spend the rest of your life with. That's terrific. However, you are now in a different position in your life, and that requires some thought and preparation. Is there a house involved? Maybe 2 of them, his and hers. How are you going to handle that? Are you both going to be on the deeds? Are you going to sell one? What happens to those proceeds? Do you want to have both of you on the deeds? How is the property eventually going to pass after both of you die? Listen to me. I've had circumstances where one spouse died and the second spouse wasn't on their deed. The deceased spouse also had no will or estate planning. So guess what? The estate was liquidated based on Tennessee law. And that meant the surviving spouse was eligible for only a child's share. Guess what? The deceased spouse's children, her stepkids, came in and liquidated the house and everything in it. There wasn't anything she could do. Ouch. That was extremely painful for the woman involved. And I'm sure it was very unintended by her husband. But he could have done something about it and didn't. On the opposite side of the spectrum, maybe there are children and stepchildren that you want to include in your estate. I'm here to tell you, unless you take specific action for that, your stepchildren and any grandchildren that are children of stepchildren will have no right to share in your estate. Once again, unintended consequences. Finally, maybe both of you come to the new marriage with separate assets that have been accumulating for years. You may want different things done with those at your passing. Be careful, because unless you take the right actions, those assets could vest in your new spouse at death and then go to your spouse's legal descendants. Your children would be just shut out. I probably have your attention now, at least I hope so. There are more of these kind of boo-boos that I run across, but these are the major ones. And I'm sure we will revisit this. So I hope you've gotten some takeaway here that maybe helps you from not making one of these boo-boos. We're going to take a quick break, and when we come back, I've got some final thoughts and some encouraging things too. Thanks. So that wraps up the major boo-boos that I want you to avoid when it comes to estate planning, and I hope you avoid some of those that would make this worthwhile. But I did want to touch on some additional ones. These are also boo-boos, but I'm calling them miscellaneous boo-boos. I don't see these as much, but they are out there, and I want you to be aware of them. So here's one. Forgetting to fund a trust. I have a lot of people that come to me that have trusts that they've created at some point in their life. Sometimes they come to me and they want to create a new trust, but they can come to me and have an existing trust. Or maybe the family comes to me after someone's passed away with an existing trust. What do we do with this? Unfortunately, I often see people have not put their assets in their trust. And this is a problem because in order for your trust to work, your assets need to be titled in the trust. Yeah, otherwise, those assets are going to be probated either with a will or without. We talked about that. If you're interested in trusts, I've had an episode kind of talking about different kinds of trusts, so go back and listen to that. I think that could be helpful. And this is a big issue when it comes to trusts. You have to fund the trust. And I'll probably talk about that some more in a future episode, but this is a boo-boo. Another one I see, MIA estate planning documents. Missing in action. Okay? I always tell people, put these documents somewhere where they can be safe and can be found. Okay? Unfortunately, sometimes people are so secretive about the safe place, they can't find those documents later on. An estate plan is of no use whatsoever unless you have those documents available to enforce the provisions that you put in place. Leave some kind of notification or knowledge or indication of where you put these things. It is no fun after someone passes away to have to go searching for wills. Trust me, the Bar Association here constantly has emails from attorneys looking for wills that are lost. It cannot be enforced unless you have the original. And if we don't have the original, that creates a whole other legal issue. Just keep them where they can be found. Okay, one place that people often keep these things, of course, are safe deposit boxes at banks. And I think that's fine, but I want to caution you about that. Here's the problem. Someone needs to have access to that safe deposit box so that they can get those documents out when they're needed. I've seen show cause orders issued by courts in order for folks to get access to a safe deposit box. If you're not on the account or there's not a specific order and you are not getting access to that safe deposit box, that creates a problem, as you might imagine, because if you die and your will's in the safe deposit box, sometimes we have a struggle in getting it. So I know I talked about joint accounts, but I always think it's a good idea to put someone else on the safe deposit box account. I also include this in my powers of attorney. Here's another issue: failing to update your estate planning. Your life is going to be different when you're 80 or 60 than it was when you were 40. So it's not a one and done. Enough said. Related to that, failing to use a professional estate planning attorney. I've talked about this. Generic documents do not work. So use someone who knows about important estate planning issues and can talk to you about these things. All of our lives are different, and we want to make sure that your document works for your circumstances. Passwords. I can't even remember my own passwords unless I write them down. Put your passwords somewhere where they can be found so that if they're needed, they're available. That's a simple thing, isn't it? But that causes more trouble. Along with that, make sure to have a complete list of your assets with your important documents. I see missing assets all the time too, and this is a multi-billion-dollar problem, believe it or not. If you're a veteran, I thank you for your service, first of all, but keep a copy of your DD-214 discharge papers with your other important documents. Some of these things date back, going on 60, 70 years. So this would solve a lot of heartache down the road when it comes to your benefits. There may be things available for you at, if you're incapacitated, or burial benefits once you pass. We need that DD-214. Put it in the file. Here's another issue. There's a strange term that's known as persterpes. What in the world is that, right? Persterpes is important when you're listing beneficiaries, and I want you to know and be familiar with this term. Persterpes indicates that if the beneficiary that you're designating dies, then the children of that beneficiary will receive the benefits. So that could avoid the problem that we talked about before. Say you give something to your son, and your son dies before you. Well, if you put persterpes there, that means that it won't go to your estate. It will go to your son's children, your grandchildren. So this is important to know. It's also important to know that that does not include your stepchildren, right? Unless they're specifically referenced in the document. Okay? So those are some miscellaneous boo-boos that I thought were worth mentioning. Obviously, there are a lot of minefields in this area of estate planning and long-term care planning, and I just want you to be able to avoid those and plan with confidence. That is the primary reason I'm here and that I've created Boomer Time. So I'd like to share a few thoughts with you as we end our time together. As you know, I'm a person of faith, and I believe in the power of prayer. I rely on it daily. I pray for all of you, too, in your circumstances. This is hard stuff, and we need that encouragement, in my opinion, and the source of a lot of anxiety. So, the Bible contains a lot of scriptures in both the New and Old Testament about anxiety and encourages us to look to God for peace and cast our cares on Him, which I know in all practical sense, sometimes that's not so easy. But I thought I'd share just a few scriptures with you that might help you in that as we conclude today. So Isaiah 41:10 says, "Do not be afraid, for I am with you. Do not be dismayed, for I am your God. I will strengthen you. Yes, I will help you. Yes, I will uphold you with my right hand of my righteousness. That's a great promise. You've got strength. You've got support from a God that loves you. Proverbs 3:5-6 says, "Trust in the Lord with all of your heart, and lean not on your own understanding. In all your ways submit to him, and he will make your path straight." I'd like a few paths straight in my life, and he never fails to help me, and I know he won't fail you. Philippians 4:6-7 says, "Do not be anxious in anything, but in every situation, by prayer and petition, with thanksgiving, present your requests to God. And the peace of God, which transcends all understanding, will guard your hearts and your minds in Christ Jesus." That's a wonderful thing too. I hope that gives you some encouragement today, because I really believe that there is a God, and he does care about us, and he can provide peace and hope. And that's part of the reason I'm doing this too. So it is my prayer that these scriptures resonate with you and give you some of that peace and hope in your journey that you find yourself in. Like I said, this podcast will be here as a help and support. And if you like the podcast, please follow it on Spotify or on YouTube, or Facebook. Maybe share it with a friend. Okay, I want these resources in more people's hands. And also, don't forget to check out my website, nancykogar.com. There are more resources, and you can also ask to subscribe to my monthly newsletter, Elder Law News You Can Use, and that's all free too. So, I've enjoyed our time together here, even though we've been talking about boo-boos, but you know what the best thing about boo-boos are? Avoiding them. So, I'm glad you know about them now, right? So I hope you've had a good time too, and I look forward to talking with you next time. Thanks. This is Boomer Time, and I'm Nancy Kogar.